Hello, how are you all? My name is Advocate Nouman Jahangir, and I am a lawyer from Pakistan, and I am practicing my law in Lahore High Court. And for the last 8 years, and my number is +923244139397. So the topic upon which I am going to talk about is a Pakistan Code of Criminal Procedure. And in Code of Criminal Procedure 1898, I am going to discuss some of its sections. And now, all those people who don't know what Code of Criminal Procedure is, uh, then for their information, I would like to tell them that the Code of Criminal Procedure is actually a unified law and a code which tells us and describes the procedure of how a criminal procedure of cases would be conducted in the courts of Pakistan. It whether any legal proceeding is being done in the lower court or in the session court on the district level, or whether it goes in the high court or in the supreme court of Pakistan. All the proceedings of the criminal matters are um, happens on this court. So now I am gonna talk about and gonna read all these sections. And actually, I have a very little time in my daily routine, and now I have started to read some sections for your information and tell you some information about the Pakistani laws. So, first of all, uh, there are so many parts of criminal procedure uh, code code of criminal procedure, and now I am gonna read the first part. So basically, it has several parts and several chapters inside it, and it has nearly 8 to 9 parts. And there are several chapters inside it, but today I'm gonna just uh, talk and discuss the chapter 1 located in the part 1, which is a preliminary. So first section is about short title commencement and extent. Second section has been repealed, and section is a reference to code of criminal procedure and other repealed enactments, expressions in former acts. Section 4 is relevant to definitions and words referring to acts, words to have same meanings as in Pakistan Penal Code. And Section 5 is relevant to trial of offences under a penal code, trial of offences against other laws. So now I'm gonna read the first chapter of Code of Criminal Procedure 1898 of Pakistan. So this is an act number 5 of 1898. It has been uh, came into effect on 22nd March 1898. So now I'm gonna read that, and I will also explain the meaning of some difficult words which will come inside it, and I will tell you what the meaning of those difficult words are. An act to consolidate and amend the law relating to the criminal procedure. This is basically telling that an act to consolidate and amend the law relating to criminal procedure means all the criminal procedures which happens in Pakistan and all the criminal trials. This act is basically to consolidate and unified all those laws relating to criminal procedures. Whereas it is expedient to consolidate and amend the law relating to criminal procedure, it is hereby enacted as follows. Expedient, the meaning of expedient. Expedient is means to uh, an action that is useful or necessary for a particular purpose, but not always fair or right. Means in law, which is an action which is necessary for a particular purpose, but not always fair and right, is called an expedient. And it shouldn't be the fair or right, but it is necessary. So it is basically telling that whereas it is expedient, whereas wherever it is in the necessary to consolidate, to unified and amend the law relating to criminal procedure, it is hereby enacted as follows. So, Part 1 states that preliminary. Part 1 is relevant to preliminary chapter and chapter 1. So, what chapter 1 basically says? Chapter 1 basically says, short title, commencement. In this act may be called this act section 1 and its rule subsection 1 state that this act may be called the Code of Criminal Procedure 1898 and it shall come into force on the 6th day of July 1898. So it will be it is said that it will be came into effect on first day of July 1898. When in actual sense it has been drafted and passed on 22nd March, but it will come into force on the first day of July 1898. So it is not necessary that the act will be passed on the same day when it has to be implemented. It can be passed much earlier than its enforcement and coming into force. But passing that act before the enforcing it is very necessary because if an act will not be passed, then it will not come into force. So, extent the subsection 2 of section 1 states that it extends to the whole of Pakistan, but in the absence of any specific provision to the contrary, nothing herein contained shall affect any special or local law now in force or any special jurisdiction or power conferred or any special form or procedure prescribed by any other law for the time being in force. So basically, what is telling that it will extend to the whole of Pakistan, but when there is no specific provision and there is nothing contrary, nothing herein contained shall affect any special or local law in force. It is basically saying that it will not affect any special or local law on any special jurisdiction or power conferred on any special form or procedure prescribed by any other law for the time being enforced. Any other law which is time beingly enforced, it will not affect those laws. Section 2 has been repealed of this code and act, and it has been repealed by the repeal of enactments notification etc. under repeal acts pending case repeal by the repealing and amending act 1914. This was the act of 10 of 1914 when it had this by which this section had been repealed. So now I'm gonna state the section 3 references to code of criminal procedure and other repealed enactments. In every enactment passed before this code come in, comes into force in which reference is made to or to any chapter or section of the Code of Criminal Procedure Act 25 of 1861 or Act 10 of 1875 or Act 10 of 1882 or to any other enactment hereby repealed, such reference shall, so far as may be practicable, be taken to be made to this code or to its corresponding chapter or section. So this section basically is referring to the references of Code of Criminal Procedure and other repealed enactments. It is saying that in every enactment passed before this code comes into force in which reference is made to or to any chapter or section of the Code of Criminal Procedure Act 25 of 1861 and Act of 1872 or Act of Act X 10 of 1882 or to any other enactment hereby repealed, such reference shall, so far as may be practicable, taken to be made to this code or to this corresponding chapter or section. This is saying that all the codes the Act 25 of 1861, Act 10 of 1872, and Act of 1882, which had been had been practiced by the people should be repealed by this code and from the passage of this and coming into effect of this code, all the enactment would be the part of this code and subsection 2 of this section 3 states that expression in former acts in every enactment passed before this code comes into force. The expression officers exercising or having the powers or the full powers of a magistrate and subordinate magistrate first class and subordinate magistrate second class shall respectively be deemed to mean magistrate of the first class, magistrate of the second class, magistrate of the third class, and the expression joint session shall mean additional session judge. So this is saying that in the previous former acts and the enactment and passage of before the passage of this act, there were the officers, court officers of the like magistrate, subordinate magistrate. They were called as magistrate, subordinate magistrate, first class and subordinate magistrate into second class shall respectively deemed to mean they will be called as magistrate of first class, magistrate of second class, magistrate of third class. Previously and prior to that, they were called as the magistrate, subordinate magistrate, first class, subordinate magistrate class, and the previously when the additional session judge was used to called as a joint session judge, but now after the enactment and passage of this act, he is now being called as the session judge.